It is Friday, March 27th, 2026. It is 4 o'clock p.m. in Washington, D.C., and you are watching Lawfare Live. I'm Benjamin Wittes, editor-in-chief of Lawfare, and I am here with Molly Roberts and Roger Parloff, both senior editors of Lawfare, in what has been a comparatively light week in the trials and tribulations department of the Trump administration. But yesterday evening was a definitely a tribulation if your name happens to be Pete Hegseth. The Northern District of California uh, picked you up bodily and threw you down on the mat in the first page of a 43-page opinion, and then kicked you over and over and over again for 43 pages. Molly, let's start with Anthropic versus Department of War. And the really important question: did Judge Lynn reform her ways and refer to the Secretary of Defense as the Secretary of Defense and the Department of Defense by its proper name, or did she keep humoring this delusional renaming and false consciousness on the part of a giant federal agency?
If I recall correctly, there was a lot of DOW in there, but if I missed something, let me know.
No, you are quite correct. She did not reform her ways, and I'm salty about it.
Well, we will say Department of Defense as many times as possible in discussing the case to make up for it, but I fear that as the litigation continues, we're going to hear much more Department of War and Secretary of War. I don't know that anybody said Sec War, which for some reason grates on me even more. So as long as
Yeah.
they keep doing the extended title or full title, I'll feel a little better.
All right. So, what did we make of what do we make of this opinion? Is there any good news in it for the government?
Oof. Not really. The only good news in it, I suppose, is that it stayed for 7 days to give them time to appeal and presumably to seek a stay from the Ninth Circuit. But otherwise, it looks pretty bad for the government. I mean, really, they lost kind of in every way possible. Not only did they lose on every action that was taken, so that includes President Trump's tweet, Pete Hegseth's tweet that imposed the secondary boycott, and the formal letter designating Anthropic as a supply chain risk, but also they lost on every legal and constitutional argument. So Judge Lynn did not content herself with saying the statute doesn't authorize this. In fact, she got to that last. She also said this is First Amendment retaliation, there's a due process problem here, and this is arbitrary and capricious. So not looking good for the Department of Defense in any regard there.
Yeah, I could not find a bright spot for Hegseth. I suppose she didn't reach the code is law question, so you could say that's a bright spot. But she really did. I mean, she had a choice. You could decide this narrowly on statutory grounds or go big on both First and Fifth Amendment grounds, and she did the latter. She included a fair bit of salty rhetoric, including the Orwellian word, the O word. And she also took the time, this is a perhaps more important point, to lay out a pretty extensive record that I think it's going to be very hard for an appellate court to go a different direction given this record. I'm curious if you see a lot of room for either the Ninth Circuit or the Supreme Court to interpret this record differently than she did, or whether this is just one like the law firm case where it's going to be super resistant to whatever panel you put in front of it. This is just a kind of the law is the law is the law kind of case.
Yeah, it's a great question. I'd be curious to think what Roger thinks there too, or to hear what Roger thinks there too. I thought that the laying out of the record was one of the. I thought the opinion was a strong opinion, but I thought she did a really good job laying out the record, and that was probably the strongest aspect of it. And she made it really clear that what had happened here was that the Department of Defense hadn't had any issue with these usage restrictions until there was this public fight about it. And she also made it really clear that there was no legitimate basis to think that Anthropic would become a saboteur, and indeed that nothing on the record showed that it had the ability to go in and access these systems after they're deployed, which feels like something that could be misunderstood because nobody really understands how AI works. So I thought it was useful that she went through the record and established that. I also had a question maybe for you on why did she do the First Amendment and Fifth Amendment stuff and not content herself with saying that, what is it, 10 USC section 3252 doesn't enable this, which is, does it matter at all that there's also this case pending in the DC Circuit having to do with a different statutory authority? And if she had just said there's no statutory authority here, could the Department of Defense said, well, we're just doing it under the other statutory authority and the DC Circuit hasn't decided yet?
Yeah, so that I think is part of the reason. I think part of the reason is also just an argument in the alternative that, if you're going to get taken up to the Ninth Circuit, which she certainly is, there are many possible ways to affirm this. Even if she's wrong on the statute, she's clearly right on the, you know, due process stuff. And even if she's wrong on that, they still have a First Amendment retaliation problem. There's a lot of things wrong with this record. And I think she just made a strategic judgment rule on all of them. And that makes it harder to reverse, actually. You have to find fault with every level of it. Roger, you have thoughts?
Yeah, I mean, there's also like Molly said, remember there's three things here. There's the Trump tweet, there's the Hegseth tweet, and there's the formal letter. So 3252 doesn't reach the Trump tweet where he purported to wipe out, just say you can't use, no federal agency can use it based on Article 2, my Article 2 authority. So without, so the First Amendment and the Fifth Amendment go to that. And it doesn't, it won't be that it's not phrased as I'm enjoining Trump from doing that. It's I'm enjoining anyone from listening to him, from
Right.
implementing what he
You
said.
must ignore the president, executive branch.
Exactly. And I think to some extent that's true of the Hegseth tweet as well, because it wasn't the formal 3252, and it did purport to do crazy things that I did purport to impose the secondary boycott and things that he's not really authorized to do.
Right. I think without the constitutional holdings, there would still be some portion of the action that would survive, assuming the DC Circuit didn't rules differently on the other statute. I forget which statute that is. But this way, I think virtually none of it is extant, at least 7 days from now, absent a stay. Roger, how optimistic, pessimistic would you be if you were Pete Hegseth looking at your appellate chances, keeping in mind that you have a very favorable panel at the DC Circuit?
Yeah, I think he's got a very favorable panel at the DC Circuit. That's Wilkins, Katsas, Rao. So two Trump appointees there. In the Ninth Circuit, it depends a lot on the panel. This is going to sound cynical and snarky, and I don't mean to, but it's just as far as, although I think the factual findings are very strong, I don't see a lot of deference being given to district court findings by appellate judges who are appointed by the other party, or at least by Trump. It just doesn't seem to be working that way. And the other way they could go, if they wanted, they could say that enormous deference needs to be paid to the defense secretary in this context. And there is something totally unique about this situation. You know, it's not like we're looking at, you know, Windows 17 or something here. It's you know, it's software that's, or I don't know if software is the right word. It's a thing that is smarter than us, and we've never had before. And so how they're going to respond to what how the president and the secretary of defense can treat that, I really don't know.
Yeah, I mean, I gotta say, I find it hard to believe that there are 5 votes on the Supreme Court for the other side of this, for the DoD side of this case. Um, I, I think this case is no different from the law firm cases or the Harvard case, and it's fundamentally a retaliation case, and it's wildly in excess of his statutory authority. So I think the case boils down to, in the absence of a statute that authorizes you to do it, can you retaliate against a company for criticizing your negotiating positions? And by the way, do it explicitly on the basis that it's a woke, you know, like they kind of gave the game away with the tweets. And I just don't see, you know, John Roberts or Amy Coney Barrett, or, you know, I have a hard time imagining Neil Gorsuch going there. It just feels to me like if you wanted to win this case, you had to do it subtly. Like there's probably some way to retaliate against them subtly, in which you don't create a giant record with a big red stamp on it that says retaliation. Um, but once you've created that record, I just don't see how you win the case.
No, it's tough because I think they wanted it to be loud, right? And the biggest problem for them, or one of the biggest problems for them, is that they could just stop working with Anthropic legally, but they wanted to make a big fuss and they wanted to say that they basically wanted to say we're retaliating, to have this show of force of, we're not going to let our, just like Higgs has said, we're not going to let the ideology of Silicon Valley dictate how we use our warfighters. So,
right. All right. Well, I asked Claude what he thought of the matter. Uh, 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 and here is what he said. First, he asked me which Anthropic decision I was talking about. He said there have been a bunch of them recently, and he wanted to make sure he mentioned that there were decisions on some products, and there were decisions on, and he wanted to make sure I was talking about the wanted to make sure he had the right case. But then
Can I just say that given that, I don't think he should have control over autonomous lethal weapons.
he doesn't know you very well, Ben.
To be fair, I did say, what do you think of the Anthropic decision? And, you know, I didn't say the judicial opinion, so he was just clarifying. So then he gave me a very good summary of the opinion, and then said, as for my own view, since this directly involves Anthropic, I'm not well positioned to offer a neutral opinion, but the legal question at the heart of the case is genuinely significant: whether the executive branch can use national security designations as a tool to retaliate against a private company for its public speech. Judge Lynn's answer, at least at this stage, is a firm no. So, there you have it. Claude taken himself out of the conversation because he's got a dog in this fight. Um, all right. By the way, which is more than a lot of journalists do. So, uh, uh, kudos to Claude for being intellectually honest and disclosing his biases. All right. Meanwhile, down in Fulton County, and I know what some of you were thinking. Some of you were thinking, where is Anna Bauer today? And the answer is she is not here with us because she is in court in Fulton County, doing the Anna Bauer thing. And so, Roger, what case is she in, and what do we know about the case? She's been in it all day. What do we know about it, and what can we say prior to her emergence from court?
Yeah, this is that suit, the Rule 41 suit, that Fulton County brought to get back its all the voter records that were taken in the search. And earlier this week, Judge Boulay, decided that the FBI agent who swore out that weird search warrant did not have to testify. That was a big ruling, and that, as a result of that, today's hearing is less interesting than it might have been. Although it's still going on, and so Anna might eventually have a lot to tell us, and I'm going to watch her Twitter or her Blue Sky tonight. She'll probably explain a lot. But
I gotta say, I don't understand what there is to talk about all day if you're not going to hear from the agent whose affidavit constituted the warrant. What's a day's worth of of evidence to hear once you've decided you're not hearing from the one person who knows something about the circumstances of the warrant?
Yeah, I believe the Fulton County has called it Ryan Macias or Macias, who is an election technology security expert, very, very well credentialed, and who was an advisor working for Fulton County during the 2020 election and through all of the recounts and audits and reviews and litigation. So he really knows all of this stuff. And he wrote a very strong declaration earlier in the case about all of the stuff that the agent seemed to have known about, because he sort of picked and chose and yet didn't refer to in the warrant. So I think that's the crux of it. If I could go back to that decision that Boulay made, and I won't go into it in detail, but basically the question was, there are these rules when you try to get a federal employee to testify. You make a TUI request, and then there are regulations that govern whether the DOJ can refuse your request or not. And so they were the Fulton County was arguing that the refusal under the TUI rules was arbitrary and capricious. And he said that wasn't, the showing wasn't made. The only thing I want to say is that, that's a complicated thing. But what you could tell is that this judge was treating, he didn't use the words, but a complete presumption of regularity here, that he was just treating this like any other underlying criminal investigation, even though on its face, it's frickin' bizarre, that you with the head of DNI there on the scene, and the backdrop of this where where Pam Bondi has been trying to get these records from every single state for some reason that has nothing to do with criminal activity. So he is approaching, and yes, he is a Trump appointee. He seems to be approaching this with as if it were with no rage. And this is actually our second data point. Remember, the mediation, the fact that he tried to put this into mediation suggests he's not as outraged as us about what happened. And he's just this is a run-of-the-mill case, and he's treating it like that.
Right, and it's a very striking difference between the way he treated it and the way the DC district court treated a similar issue that arose in the context of Dan Richman's. It's also a Rule 41 petition in which they say, wait a minute, for political reasons, you've run roughshod over Fourth Amendment stuff because you're so eager to get, in Danny's case, Jim Comey, or in this case, the grand conspiracy or whatever, and in one case, you have a relatively rapid look under the hood of that affidavit and a ruling from the DC district court. This is not an appropriate search to have conducted of Richmond's phone, and you have to give it back. And there's all kinds of, and in the other case, you have I don't know what they've spent the day talking about, but it doesn't seem to be whether that search warrant was appropriately issued.
Yeah. And we did get a short report from Anna during a break, so I can relay that. She says that Boulay seems skeptical that they need the originals back, they being Fulton County, because DOJ gave them a digital copy of the records. She also said that DOJ keeps asking Macias what the agent knew and the agent's state of mind, I guess, to show that he doesn't know that. And so Abby Lowell seems to be saying that they've opened the door for Boulay to reconsider whether to quash the subpoena, since they've made an issue out of the agent's state of mind. I predict that will not succeed.
Yeah, I suspect not. All right, let's go to a place where judges are a little bit more irritated, which is the District of New Jersey. When last we checked in, they were throwing prosecutors out of court. And now the prosecutors actually seem to have capitulated. What happened in New Jersey this week, and do we now have resolution to the long-running who's wearing an Alina Habba mask, or which mask is Alina Habba wearing, I guess is the right formulation of it.
Yeah. So I'll set the stage here. This is the battle over the U.S. Attorney's Office for New Jersey. And remember, Habba was appointed as interim, and they could not get Senate confirmation. They couldn't get a vote because the two, Booker and the other senator, blue slipped them. And so then they tried to get her in anyway through some shenanigans. Judge Brand ruled that she had been appointed unconstitutionally in August. They appealed, and while they appealed, she kept signing new indictments. And then on December 1st, the Third Circuit affirmed, and December 8th, instead of appointing in one of the ways that the statutes permit, DOJ Bondi appointed 3 people to run the office, a triumvirate, all of whom she could just appoint herself, she said, without any confirmation or approval or anything. Brand struck that down on March 9th and was really very angry about what was going on, and also suggested that those people in the interim that she was signing her name to while it was on appeal, he was going to have to consider whether to throw out those indictments. And while that was going on, another judge really hit the, he was going to do a sentencing hearing, Judge Qureshi. There were other things on his mind as well that were pissing him off, but he wanted to know whether this triumvirate was going to create an appellate issue for the validity of this sentencing, among other things. And when the the chief appellate guy began to speak, he hadn't had a notice of appearance, and he threw him out of the room, out of the courtroom. Wouldn't hear from him. Nearly had him removed. But more important, he ordered that the triumvirate would have to come and testify before him on May 4th. They would be sequestered beforehand, and they would have to each testify about what the hell was going on there. And one thing he was concerned of was apparently Haba is still with DOJ, and she'd been seen in that courthouse. And so he wanted to know, is she still the puppet master, and what's going on? So apparently, and so what happened?
Alina Haba has been called many things in her life, but I think this is the first time she's ever been called a puppet master.
Right. Okay. Now the last, well, of course, Halligan herself was called a puppet, but that's a different story. But anyway, on March 24th, which I think is that Monday or Tuesday, we learned that this had all been resolved. The U.S. District Court had appointed Robert Fraser, and the DOJ was very happy with him. Then an article came out in the New Jersey Globe by Joey Fox and David Wildstein, and gave us some of the background, which is quite interesting. The Chief Judge, Renee Marie Bum, had been negotiating with Todd Blanche, the Deputy Attorney General, for several days. Bum is one of the very few Republican judges on the District of New Jersey bench. There's 17 judges, mostly Obama and Biden. So they agreed on Fraser, who's 59, he was a career guy. He's 20 years in DOJ, was a Manhattan DA beforehand. But they would not appoint him until he verified that he had voted for Trump all 3 times. So there was a little litmus test. And then apparently their first choice was Jordan Fox, who was one of the triumvirate. She was 5 years out of law school. She's 30. The judges wouldn't go along. And then their second choice was Lamparello, who was another member there, and he wasn't approved. Anyway, they finally agreed on Fraser, and it seems like a pretty good resolution. Booker and Senator Kim were not consulted, by the way.
So is the May 4th hearing now off? Or?
Yes, the next day, Qureshi. Well, the sentencing will go forward, but those people will not testify.
And is Fraser going to be nominated, or is he just appointed by the court pending somebody else's nomination?
I think that's a 546D appointment, and I think it can just last. I don't think I mean, he could try to get another person at Senate confirmed, but I don't think he will.
All right.
Or at least those New Jersey reporters didn't think he would.
So, Roger, the state of Minnesota brought suit in the District of Columbia court in DC District Court in Washington over withholding of evidence in the killings of Renee Good and Alex Preddy and the shooting of another gentleman. I first of all, I'm surprised this has taken this long. But secondly, I'm a little bewildered as to why the suit is in Washington rather than in Minnesota, where they have this bench full of super angry judges who really understand the magnitude of the misconduct that the Justice Department and the Department of Homeland Security have been involved in Minneapolis. So I like, tell us a little bit about the suit, but also like there's clearly a strategic judgment to bring it here rather than there. Why didn't they just like, go to any of 10 judges in their district and say, here you go, Judge Troheim or Judge Bryant, or I mean, like these are angry judges. Why are they going around them?
Well, it's a good question, and it's going to be an issue. I think it's going to be an issue. If you remember, they actually, the Minnesota Bureau of Criminal Apprehension brought a suit to try to get access to the Preddy crime scene. And that one went before Eric Tostrud, who is a Trump-appointed judge in Minneapolis, Minneapolis. And he denied them the emergency relief. I think he felt that by then DOJ or FBI said they were going to look into it, and he saw no reason not to believe that they would, or insufficient reason to believe that they wouldn't. On March 24th, so this week, they voluntarily dismissed that suit and brought this one here. So if you are, I suspect the government might think, oh, they are trying to get away from the Trump judge who ruled against them, and trying to get away from the Eighth Circuit, which is almost all Republican, if not all Republican. I can't remember appointees. And so here it's different in some important ways. It's all three shootings, and it's about TUI demands. And the word TUI did not come, same sort of demand I mentioned earlier that was at issue in the trying to get that FBI agent to testify in Fulton County. And so it focuses on TUI demands that were denied by DOJ and by DHS. And so in that sense, jurisdiction is here in DC, and it makes sense. But yes, it might be that they feel that this is strategic, that maybe the government will make some claim that this should have been brought in front of Judge Tostrud. It's fundamentally the same legal arguments, 10th Amendment, APA, arbitrary and capricious. And so it'll be interesting. I forget. Oh, it's been assigned to Emmett G. Sullivan, who is, I think, a pretty different judge than what I've seen with Tostrud so far.
That's a That's going to be that's a difficult draw for the government.
Yeah. Yeah. And if you remember, he was the one who resisted Bill Barr's attempt to dismiss millionaire Mike Flynn's case, the case against Mike Flynn, General Flynn, who just incidentally won or settled his Federal Tort Claims Act case against the United States for $1.2 million.
Molly, remind me who Bill Pulte is, because it's been a while since we've talked about him. And I think I'm probably not alone among the audience for having willfully forgotten about his existence.
Yeah, I was going to say I envy your ability to forget. Bill Pulte is the Federal Housing Finance Agency director, but he has also turned himself into something of a fishing expeditionist against Trump's political enemies. So we've talked about Bill Pulte a lot before in the context of prosecutions on allegations of mortgage fraud. So Lisa Cook, Letitia James, and Letitia James is what we're talking about now. So Bill Pulte, the mortgage fraud made a little bit of sense that he was looking at that because Federal Housing Finance Agency director, although there was some sketchy stuff going on, it seemed possibly involving how he got information that he got to dig up some information about Letitia James from Fannie Mae. But anyway, what we've learned this week is that he has made 2 criminal referrals. He made criminal referrals in the Letitia James mortgage fraud case, but that he's made 2 new criminal referrals, and these have to do with insurance fraud that he is suspicious Letitia James has committed. The referrals were
And is
made.
this housing insurance? Like, what does this have to do with the?
Yes, exactly. So
Okay, so it's like the connection to his day job is that it's homeowners insurance.
yes, that is the connection to
Not
his day
like
job.
life insurance. She's taken out a policy on herself or something.
Yeah. So, there's like the more plausible connection. And I don't think, unless I'm wrong and have forgotten, just as you willfully forgot from some stuff, I don't think he's involved with at all with the investigation that presumably is still ongoing, if it ever really existed, into her hairdresser, which has nothing to do with houses. That has to do with
Right. That has
Range Rover or something.
and it's in New Orleans.
Yes.
Because she has a house in Norfolk and she's the Attorney General of New York, but her hairdresser is in New Orleans.
And wait till you hear where these criminal referrals are to. One of them is to U.S. Attorney Andrew Boutros in the Northern District of Illinois, and the other is to U.S. Attorney Jason Redding Quinones in the Southern District of Florida.
The inevitable Jason Redding Quinones.
Yep. So
the father of the grand conspiracy investigation.
Precisely.
It all, in Molly's case, it all leads back to the Southern District of Florida.
Yeah, I've got a new string of red thread to connect from one place to another for my bulletin board. But the reason that it's to those 2 districts is so the properties in question, turns out they're the same properties we were talking about with the mortgage fraud stuff. They're in Norfolk, but the insurance companies for the 2 respective applications are in the jurisdictions that these referrals are to. So very convenient, a good way to get yourself to the Southern District of Florida.
So wait, but is it the same?
It's the same properties.
Activity?
Yeah, basically. So in fact, so the information, the kind of tip off to Pulte, it seems, was from Mike Davis. We're going to grand conspiracy again here, but Mike Davis, who's kind of a conservative activist, advocate, good friends with Jason Redding Quinones. So that's something that he has said himself many times, my buddy. He dug these up and we've seen them because they showed up in the second indictment of Letitia James. So, or the failed, anyway. So we've seen them. And it was always odd in the mortgage fraud cases because when you looked at the documents, a lot of what they were saying she had done wrong did have to do with insurance. So the allegation here is that she made representations that this house would be occupied by a single adult, no children, and then her niece, may recall hearing about her niece, lived there with her 3 children. So, and then so that's one of the properties. These are the 2 properties we heard about in the
Hmm.
old case, right? So
Same.
that's one of the properties. That's the one that's to the Northern District of Illinois. And then the one to the Southern District of Florida is she represented that the property would be unoccupied 5 months out of the year, but it was occupied year round. So they couldn't win on mortgage fraud, the occupancy fraud stuff. So they said, well, I actually made the same misrepresentations that we were using to allege occupancy fraud, but now we're alleging insurance fraud.
And is there any indication that either Quinones or the U.S. Attorney in the Northern District of Illinois is engaging on these referrals?
Not that I know of. They're very new. They were just made on Wednesday. So I think we don't know yet. I wouldn't be absolutely shocked if Jason Redding Quinones acted on it. On the other hand, he does have his hands full with the grand conspiracy.
Right. And the thing about the grand conspiracy is that it's
So grand.
grand.
It's so
And
grand.
so it takes up a lot of time and
Yep.
energy because it just keeps growing.
Yep.
All right. Speaking of really important cases involving false statements and things that, the world will not sit still unless we resolve, the government made a rather interesting admission in the Jerome Powell case, Roger, which I don't mean to be reductive, but kind of boils down to that there was no evidence that he'd done anything wrong. What was the context here? What did they say? And how does the investigation continue once you've stood up in court and admitted that?
Yeah. So the Judge Boasberg directed that the hearing before him before he quashed the subpoena could be unsealed in a redacted form. And so those transcripts became available. The Post was the first to get them. I've got them now. We now have the back and forth, and Boasberg put it to him, what false statements did he make before Congress? And the AUSA, I think he's now head of the criminal division, Masuko Lateef, said, well, we don't know, is my first answer. However, there are certain areas that he addressed that caused concern. And so Judge Boasberg said, and then what evidence is there of fraud or criminal misconduct in relation to the renovations? And he said, again, we do not know at this time. However, there are 1.2 billion reasons for us to look into it. He's referring to $1.2 billion. The cost overruns, I don't know what are not 1.2 billion. They're about 600 million, I think. But it depends on whether you use Trump's figure or whether you use the real figure. But anyway, that's all they had. You had asked a question about, and Boasberg also said, invited, you can submit under seal, ex parte, just you and me, not the Federal Reserve's lawyers, what the evidence is, which I guess he's done in the past. And he said no. He declined. So you had asked last time about, what was the standard? And of course, the standard is the idea is that if the sole and dominant purpose of the subpoena is improper, that you can quash it. And the burden is on the person seeking, the target, or the subject of the investigation. The the way Boasberg looked at it, and I don't think there's existing law on this, but it makes a ton of sense, was sort of a sliding scale. And he put it this way: the less evidence you have of wrongdoing, then the less the target has to show that there's an ulterior motive here. And or conversely, the more evidence you have of misconduct, then the more they would have to show of ulterior motive. So that's sort of the judgment he made. And here there was zero evidence of wrongdoing and a ton of evidence of misconduct. And so that's how he resolved.
But I'm still hung up on an antecedent question that Boasberg doesn't address, which is, what is the predicate for an investigation at all? You know, that there's you can't just open an investigation based on nothing and then say, well, this is relevant to it, and issue a grand jury subpoena on the basis of it. Under the Attorney General's guidelines, you have to have an articulable factual predicate for reason to think that there was a commission of a federal crime in the beginning. And otherwise, you're just investigating a person. And is clearly what's happening here. And of course, what's the motion to quash is for the subpoena, not the investigation. But you know, what Boasberg is really saying here is, I don't think there's a factual predicate for the investigation. And, you know, he doesn't get to say that because he's not supervising the investigation. He has a motion to quash the subpoena. But I'm saying it, like, there's no predicate for the investigation. The predicate for the investigation is Jerome Powell testified, and there were cost overruns.
Yeah. I think if you don't have evidence of vindictiveness, you know, if there are no tweets, if there's no history, and somebody is just sort of curious, gee, that's a big cost overrun. I think that's a tough case because you can't enforce the judicial manual or the justice manual or whatever they call it right now.
All right. I am told that Anna Bauer is out of court, and is on her way. So we will break in, and whenever she shows up with Fulton County stuff. In the meantime, let's talk about New York versus Hegseth, New York Times versus Hegseth. Speaking of cases in which the government is not complying with court orders, Judge Paul Friedman ordered the Pentagon to stop its highly discriminatory behavior toward disfavored news organizations. And the Pentagon basically said, pound sand. What is the current status of this, and where are we in the litigation?
Yeah, so last Friday, while we were here on Lawfare Live, Judge Friedman ordered the Department of Defense to restore press access to these 7 New York Times journalists, and then a bunch of the other disfavored organizations that had had their credentials yanked started pressing the Pentagon to get theirs back too. And his ruling said that it was a violation of the First Amendment, that they were effectively retaliating against news organizations that didn't like President Trump, but news organizations that wanted to ask hard questions and do the work of journalism and not just accept exactly what the Pentagon told it at any time and asks nothing further. So that's primarily First Amendment, but also he said that the Pentagon had given itself unbridled discretion to enforce the rules, and he said that there was a violation of journalists' due process rights. And he said, well, he quoted himself at oral argument in his ruling saying, this is what the First Amendment is all about, kind of now more than ever sort of language. So it was a pretty robust ruling and order. And the Department of Defense, by the way, this is New York Times versus Department of Defense, and he said Department of Defense in the hearing. So a little bit of contrast with what's going on in California there, but I believe that's because the New York Times did not decide to say Department of War in its complaint.
Yeah, I think that Judge Friedman would have said Department of
Regardless
Defense
of what
anyway,
the Times
but
had said. No,
that's
yeah, well,
just a
you
guess.
know, more of a knock on Judge Lynn then, I suppose. But in any case, the Department of Defense said, okay, fine. Here are our new policies. We're going to change the wording of some of the rules. We're going to be more explicit about our definition of what activities are prohibited, because the judge had said, it sounds like you are saying that they can't even ask a question about any information you don't want to be public. So the new version replaces the word solicitation with intentional inducement of unauthorized disclosure. And a special advisor to Pete Hegseth said in an interview to the New York Times, I believe, we used more words to say the same thing and to foreclose creative misinterpretation, saying, hey, court, you misinterpreted, and we're giving you the runaround here. So
and I just want to say, for all of you who are considering making public disclosures that you are evading court orders by using word games, this is not, generally speaking, a good idea. I'm not your lawyer, but when you are trying to evade a court order by playing word games, it's generally a good idea not to announce that you're doing that.
Yes, no, not a good idea to announce it. Not a good idea to announce it to a journalist for the same paper who is suing you over this, because then they, of course, went back into court and quoted that in their new complaint. But I'll get there. The other thing the Department of Defense is doing is closing the workspace for credentialed journalists entirely and setting up a new annex for the press. And the press can go hang out in the annex, and if they want to do anything in the Pentagon, they have to get a DoD escort. So that's what they're doing. They said they had to do that to preserve security without conceding the validity of the court's analysis. So that's what they said they did. And of course, this was not pleasing to the New York Times. I don't really imagine it'll be pleasing to the judge either. But the New York Times said, we're going to go back to court because this still imposes unconstitutional restrictions on the press. It's a thinly veiled attempt to flout the court's ruling, was their language. And it's trying to do the same thing. It's trying to prevent journalists whose editorial viewpoints the Department of Defense dislikes from doing journalism. And so now we are going to have a hearing on the New York Times' new motion to enforce on Monday. So I will be at that hearing, and we will see exactly how pissed off Judge Friedman is.
Well, Judge Friedman is an affable, friendly man, but I think this is going to test his affability and friendliness. All right, Roger, let's do our immigration roundup for the week. It's a little bit more of it than last week. We have a Southern District of New York case about ICE arrests at immigration courts, in which the Justice Department made a rather startling admission. Tell us about it.
Yeah, speaking about testing the affability of a judge, here's approximately what happened, and I'm still getting up to speed on this. But in August, this suit was filed, August 1st. African Communities Together versus Lyons. Kevin Castell, I don't know if that's the pronunciation in Southern District, George W. Bush appointee. It was challenging a new policy of arresting non-citizens when they came to their immigration court hearings. So this was reversing decades of policy and decades of policy that had been reduced to writing in 2021. And they were challenging this new policy basically as arbitrary and capricious under the APA. And also some sort of common law privilege arguments and things. In September, that's briefed. He issues, Judge Castell rules for the defendant on this issue as far as preliminary injunction. He says that, the record's not fully developed, but at this time, they call it the change was embodied in a guidance that came out March 27th of 25. They called that the new guidance on arresting at courthouses. And he says, I can't say that on a preliminary injunction that it's arbitrary and capricious. That's a high bar. So they continue briefing, and they're heading toward a summary judgment ruling. And then on March 24th, the AUSA files a letter of, quote, material mistaken statement of fact, unquote. And I have to say, the AUSA's letter is a good letter. It does not gild the lily. It's sort of refreshing. It's frank. But it says, this morning, counsel for U.S. ICE informed the undersigned that, in essence, the March 27 guidance does not and has never applied to civil immigration enforcement actions in or near immigration courts. In other words, the whole subject of this lawsuit was never covered by this guidance, is what they're now saying. And then he attaches to it an email that he was shown, issued a few days earlier from the assistant director of field operations for ERO, the enforcement and removal operations, that styles itself as a reminder that the previous guidance does not apply to immigration courts. So the government, the U.S. attorney goes on to say, so the portions of 4 briefs and oral argument that they gave were wrong, and a portion of his earlier ruling will need to be reconsidered. We deeply regret this situation. And then he said, it was not caused by lack of diligence by the undersigned attorneys. The undersigned were specifically informed by ICE that the 2025 ICE guidance applied to immigration courthouse arrests. In addition, we discussed with and obtained the approval of assigned ICE counsel before filing every brief in this case and making any oral representations to the court. We also transmitted copies of the court's orders, the transcript of the September 2nd oral argument, and plaintiffs' filings to ICE counsel throughout the litigation.
Look at this unitary executive here. One arm throwing the other under the bus.
Based on our discussions with ICE today, this regrettable error appears to have occurred because of agency attorney error. It's signed by the 2 AUSAs and Jay Clayton as the U.S. attorney. And the next day, Judge Castle issued a very brief order. It said that the U.S. Attorney's Office shall preserve all communications between and among a member of the U.S. Attorney's Office staff and or any defendant in this action or his or her predecessor or successor or subordinates or representatives, including the, quote, assigned ICE counsel. The same regard, it's a preservation order. It's like everything that you have said up until now, you preserve it because I'm going to look into this.
Well, again, for those of you who are considering long-term misleading of federal judges through Justice Department counsel, this is a good cautionary tale. It may not be the best idea in the world. Roger, speaking of government wins, however, the mandatory detention policy that almost every non-Fifth Circuit court in the country has rejected has found a receptive audience in the Eighth Circuit.
Yeah, this was another, not a big surprise, but this is that mandatory detention policy we've talked about before, and Kyle Cheney has been all over it. But the government asked for expedited appeals in two circuits, the Fifth Circuit and the Eighth Circuit, and slow walked all the other circuits. And now it's 2-0 at the appellate level, even though it's about 2,000 to 100 at the district judge level. And it was 2-1 in both courts. I can't really say political lines. Here it was a George Bush judge and a Trump judge against a Trump judge. The dissenter was a Trump appointee, Ralph Erickson. It's a pretty strong dissent. But anyway, that's where things lead. I think we're waiting to hear from the Seventh Circuit will probably be next in a sort of messier case. We've heard from them already that they were doubtful of the Trump policy.
But this is going to the Supreme Court, right? I mean, it
has to, yeah.
Because eventually they're not going to be able to keep it from every other circuit forever. And eventually you're going to get some circuit that's going to say what is the standard view of most judges who've looked at this. And at that point, you're going to have a conflict in the circuits, right?
Yeah. And we do have the First Circuit is coming along, and maybe the Ninth. So, yeah.
All right. Also in the Eighth Circuit, we have movement in Mr. Ishihara's case. He is, I think his technical title is the poor schlub who got held in contempt for being the official sort of scapegoat of the Justice Department, even though he's a Defense Department lawyer, for all the problems in habeas cases in Minnesota. Has he been taken out and put in the stocks yet?
Not yet. Remember, this was he was there was a civil contempt order, and it was purged because the outstanding issue was the property of the petitioner had not been returned to him after he was finally released and then returned to Minnesota. But they did get the property back to him within the 24 hours, and so he didn't have to pay a dime. And the U.S. Attorney's Office sued, appealed anyway. And the question was, was there standing? And in fact, a pro bono attorney for Hogan Lovells filed a brief saying there was no standing, and it was moot. Sort of different ways of analyzing it. And now they've filed
clearly right.
Yeah. And there's some fairly good, it seemed like there was some good law on it in the Eighth Circuit. They have filed a lengthy brief trying to rebut that claim, saying he is based on reputation, damage to reputation. But they also give a hint of what their substantive defense will be, which it appears to be that you can't punish Ishihara for ICE's failures. Now, of course, Ishihara did plenty himself.
He had some failures of his own.
Yeah. This is also an argument that was never made at the hearing, where the contempt order, so I think it's waived. But also precisely because it was purged, we don't know if she ever would have imposed it if it were truly ICE's fault. If ICE had not been able to return the property and Ishihara had done everything conceivable, including like telling ICE what the order was, which he hadn't done before, I don't know if she would have held him in contempt. So I think that's why this is they're, not justiciable. But anyway, that's where that one stands.
All right. Finally, the government has not given up on deporting Kilmar Abrego Garcia to Liberia. And you think, for those of you who who think you may have to give up on a dream, let this be a lesson to you that you keep doggedly pursuing the oppression of a guy who just wants to get deported to Costa Rica, which is happy to have him. You might eventually get there. You might eventually get to send him to Liberia. What is stopping the government today from deporting Kilmar Abrego Garcia to the country he doesn't want to go to? And what does Polacini's long-suffering federal judge, Polacini's, have to say about this quixotic motion?
So the government moved to dissolve the injunction that is preventing them from removing him, among other things, saying they are now ready, willing, and able to deport him to Liberia. They got
a country to which he has no connection,
No,
doesn't speak I guess they speak a lot of English in Liberia, but he, it's not a country that he's got ties to. Is that fair to say?
That's right. And now they've said they attach a declaration saying they can remove him within 5 days of lifting the injunction. They can get him on a flight. And then also they've submitted an open question was, why won't they send him to Costa Rica, where he is willing to go,
and which is willing to have him?
Which is willing to have him, said, this was part of the guilty plea he was offered. If he'd plead guilty, they would send him to Costa Rica. And so we got the answer in from Lyons in a declaration, Todd Lyons. And it's two parts. One is, first, he had to ask for this in 2019 when he went before the immigration judge in his first case, when the order of removal and the withholding of removal were issued. Of course, that's unrealistic because nobody at the time was doing third country removals, and neither attorneys nor judges were anticipating such things, and the immigration judges weren't really discussing such things. The second was this, that significant political capital has been expended in negotiating with Liberia, high stakes negotiations, political negotiations. And so abandoning agreements negotiated at the highest levels of government could cast doubt on the diplomatic reliability of the U.S. So sending him to Costa Rica would be prejudicial to the United States in that sense. He did not mention anything about the earlier diplomatic negotiations expended on Costa Rica. And he also did not, if you remember, the position in court at the DOJ attorneys implied that Costa Rica would no longer take him. And then that
turned out to be a lie.
That evening, Costa Rica denied it. And they did not raise that Lyons did not raise that as an issue. They also asked for a ruling by April 17th and say that if they don't get that, they will treat it as a denial, and obviously they will appeal it. One thing that's going on is that they are applying, the guidance on third country removals that the DVD court has now ruled illegal in a summary judgment. That's Brian Murphy, who's been overturned twice at the Supreme Court. So, but nevertheless, that's going in front of the First Circuit, and it's a fully developed record, and it's no longer issues like there's no longer an injunction involved, which is an important stripping issue. So it is a different posture, and that's supposed to be. I think it's going to be argued in May. I think they want to get this wrapped away before the DVD case might possibly, God forbid it's affirmed, this whole theory of theirs, the third country removal, would sort of evaporate. It would have to be reworked and so on. So I think they want to get that done.
All right. We are still waiting for Anna Bauer. And so while we are waiting for her, we're going to deal with the one audience question that has cropped up, which is from Andrew, who asks, the defense in U.S. versus Cole, the January 6th pipe bomber, filed a motion to dismiss based on the presidential pardon for January 6ers. Judge Ali has not yet set any schedule for briefing. Do you think this motion has a chance to succeed? Can the president clarify that the pardon does not cover Mr. Cole? So let's take the second question first. No, you cannot clarify a pardon after the fact. Once you've issued a pardon, the text of the pardon is what governs. But in this case, the text of the pardon is remarkably unfavorable to Mr. Cole. I don't have it in front of me, but it identifies two categories of people. One is 15 or 16 named individuals whose sentences it commutes: Stuart Rhodes, Enrique Tarrio, blah, blah, blah. And the other is all other persons convicted of crimes in connection on or around January 6th, the Capitol on January 6th. And Mr. Cole is not convicted of any crime. He's in fact innocent until proven guilty. So unluckily for him, he was not caught until the Trump administration, because I suspect had he been caught earlier, he would have slipped through and been covered by that catch-all. But it is limited to people who were convicted. He had not even been charged at the time. So I think I think the technical term is crap out of luck on this. It's a good try, and I would argue it too if I was his lawyer, but I don't think he's going anywhere. And we are joined by Anna Bauer, who has been freed from court in Georgia. Anna, give us the lowdown. You're muted.
And
Yeah, you're good.
Freed is a great word to use because it was a long day. The hearing over the Fulton County motion for return of election materials began this morning at 9 a.m. before Judge Bouley or Boulay? What did we decide?
I think it's Boulay, but you were the one in court with
Okay.
him.
You know, I don't know though. Everyone just said Your Honor. So, and I don't remember when they said the Honorable presiding, exactly how they pronounced it. So forgive us, Judge Bouley or Boulay. I will go with Boulay. So this morning, the hearing started. It was an evidentiary hearing, and it came on the tail of Judge Boulay entering an order in which he quashed a subpoena that Fulton County had issued for the testimony of Hugh Evans, who is the FBI agent who swore out this affidavit that resulted in the seizure of Fulton County ballots. And, you know, I actually was a little bit surprised about that. But it's if you read the order, it has to do a lot with the standard that applies in the 11th Circuit to a review of a denial of a TUI request. We talked about that last week, I believe, which is, you know, these regulations that kind of provide for considerations that the government must look at when they're deciding whether or not to allow someone within the department to testify. And in this case, the government said, sorry, we don't want Evans to testify because there's all these various privileges, including law enforcement privilege and other things. So they denied that request from the Fulton County plaintiffs, and the judge looked at it and said, oh, well, I can only, say overrule that basically if it was arbitrary and capricious. And he ultimately decided that, it wasn't. And so he quashed that subpoena. And that right off the bat kind of, at least, my gut instinct was that did not bode well for the plaintiffs here, because a large part of their argument centers on this question of the state of mind of the agent, and the timing of the investigation. One of the big things that they alleged was that there were a bunch of omissions in this affidavit about, how election processes actually work, how the selective kind of cherry-picked facts were misleading, the fact that there were a bunch of investigations into similar conduct already, and that they ultimately determined that there wasn't intentional wrongdoing, that kind of thing. And they have to show callous disregard of constitutional rights, and that's a very high standard. And so if you can't even get to the point of questioning the agent about, what he did or did not choose to include, then you're already kind of at a disadvantage. There was a possibility,
So
though,
what did
that
they
maybe
spend the day on? If you're arguing about the integrity of a warrant, and you're not going to hear from the agent who swore out the affidavit, what do you have a day-long evidentiary hearing about?
Well, so the things that the agent could testify to was like his own state of mind, but you can still have someone testify to just generally, what's not in the affidavit, because and then also the fact that the affidavit at various points will kind of reference these other investigations or will reference a contrary view, but won't include the specific exculpatory details that are actually really important to know, or will kind of make a broad statement about the importance of ballot images, for example, but then won't explain really what a ballot image even is or how it fits into the election process, or the fact that it doesn't actually really have anything to do with tallying votes, which is important for the statute here. So what happened, but actually it was kind of surprising, because we got into the hearing this morning, and I'll kind of just take you step by step of what happened. We got into the hearing this morning, and I figured, since this is an evidentiary hearing, that we'd start right off the bat with just a witness being called. But instead, Abby Lowell, I think, assuming that the judge would just be interested in judicial efficiency and that kind of thing, decided to start with a very lengthy kind of opening statement that lasted for nearly an hour or over an hour.
Abby Lowell likes opening statements.
Yeah, and he went through, basically all their arguments without having presented any of the evidence and gotten it into the record. But he did that under the, I think, assumption that he said at the start, like, Judge, I'm going to let you tell me whether you want to hear from Mr. Macias or whether that declaration, because Macias is the election expert whose declaration they earlier submitted. He said, Judge, you can just rely on the declaration. I'm going to let you tell me whether you want to hear from Mr. Macias. But once he got through this whole argument that I'll come back to you in a minute, that caused some, the government really objected once it finally stood up to respond to this idea that the plaintiffs could just, have a declaration be admitted at an evidentiary hearing without the ability to cross-examine him, that kind of thing. So then there was a whole side squabble about, do the federal rules of evidence apply here? Can the judge just basically admit the declaration? That kind of thing. Ultimately, later on, Lowell's team decided to call Macias, the elections expert, and then a second witness. But before we got to that point, Lowell started his argument, again, lasted over an hour, by talking about the timeline, and they're kind of making like a pretext argument here, because back in, if people recall us talking about this, back in November or December, the Civil Rights Division filed this civil lawsuit in which they were seeking the same records that were ultimately seized from Fulton County related to the election. Fulton County, that suit was ongoing. And as it was ongoing, after Fulton County made it clear that they weren't cooperating with some of the letters and then the suit that DOJ filed over getting these records, all of a sudden, this search warrant materialized, and the government seized the very same records that the Civil Rights Division was seeking through this civil suit. So Lowell's team is kind of making this argument of like, the timing is fishy here. It seems like what happened is that DOJ couldn't get these records through civil litigation. And so as a last resort, they came up with this idea for a search warrant. Judge Boulay seemed to actually take this pretty seriously, this argument. He had some tough questions for DOJ about it in terms of like, I do think that if this is true, it would go to callous disregard, which is the high standard that you have to meet here. So tell me, counsel, like, is this true? And DOJ said, the attorneys who were there said, oh, we're not aware of any, meeting in which there was this conspiracy to come up with a search warrant because the civil litigation wasn't working out. But they also said that they only joined the case after this motion was made. They were relatively new to the case, so they aren't aware clearly of all of the background of how the Fulton County search warrant came to be. So although Judge Boulay seemed to be kind of satisfied by the DOJ counsel representing that, there was nothing like this that happened, at the same time, Lowell's team was like, well, Judge, like, not being aware of something is not the same as something not happening. And this kind of went to like a broader theme throughout the hearing that I felt was very noticeable, which is that Judge Boulay seemed to be operating under the old presumption of regularity, that, this idea that a search warrant is facially valid, that the government's representations can be taken in good faith, and so can the FBI agents. And it all kind of just gave you this feeling of like wanting to because, you're sitting there like, we all know what's going on here.
Rule, right? And we were talking about this actually before you came on, that, there are judges for whom the world is the normal world, and there are judges for whom we're in a different world with respect to interactions with the government. So how did he leave things?
And
what is before him right now?
Okay, so let me, and I'm sorry if I'm like going in too much detail. I just, it just got out of this hearing. And so I'm like really in the weeds with it, thinking about it. But two things that I will say in addition to what I've already said. One is that in response to what you just mentioned, Ben, I think the Northern District of Georgia has been more insulated than some other districts from the erosion of the presumption of regularity in districts like, in Minnesota, in New Jersey, in DC, in EDVA, places where there have been these really highly politicized investigations and where there are these appointments issues with very politicized U.S. attorneys. So it may be the case that Judge Boulay, has not been confronted as some other district judges, including Trump-appointed district judges, with this kind of erosion of the presumption of regularity. That aside, what else happened at the hearing? We ultimately heard, as I said, from Ryan Macias, who is the elections expert, and he walked kind of piece by piece through why it is that there are all these omissions that are very misleading in the affidavit, basically kind of repeating many of the things that were in his declaration. I also wrote a piece that talks about some of these omissions that people can read if they're interested in it. And then we also heard from Shay Alexander, who is the clerk of court, who is the custodian of these records. That was basically just for the plaintiffs to establish that she had an interest in, custody in the records, and then also a need for the return of the records. And that part, I think, is on the flip side of things in terms of Judge Boulay's, kind of attitude towards the parties, is the thing he seemed pretty skeptical of in the plaintiff's arguments is like, why do you need these original ballots returned? Because we learned in the course of this hearing that the Justice Department has provided what they say is a digital copy of the records that they seized. So the only question that remained at the hearing was, can Fulton County get the originals back? And Fulton County, and the clerk on the witness stand, made some arguments about, I need them to fulfill open records requests. Need them because there's all this other litigation that's ongoing about these records. There's some state court litigation that's ongoing about it. And I think that Judge Boulay was pretty skeptical of this idea that, like, there's a real need, looking at the balance of equities, that could overcome, this fact that there's an ongoing investigation that the DOJ is pursuing. And then also harm as well that kind of ties into those arguments. I think that he just was not fully sold on this idea that there's irreparable harm, and that there's a real need for something beyond the digital copies of the records for Fulton County. What else am I missing? So where did he leave it? He left it without telling us, ultimately what he will rule, how he will rule. So I don't know, but my overall thought is that he seemed pretty skeptical of the idea that they of granting the relief requested for the return of the original ballots. He seemed willing to accept many of the government's arguments about the kind of facial validity of the warrant, the presumption of the agent acting in good faith. In terms of the omissions, there was one omission that he was really concerned about, but otherwise he kind of pointed out several times, like, well, even though they didn't mention this specific detail in these reports or investigations that have happened at the state level prior, they did at least reference that report. And so is that not sufficient, the fact that they kind of reference the report? So I think ultimately, Ben, I would guess that he's not going to rule in favor of Fulton County, but he wasn't entirely it wasn't entirely straightforward in terms of how to read him, so I'm not sure. One other thing that I will mention is that we learned there were some communications between the magistrate and the government prior to the issuance of the search warrant that related to a change in the language in the warrant, and in one specific paragraph, government actually amended that language was or those emails communications were admitted into evidence, and so should become public record at some point. And there was a secondary hearing after the evidentiary hearing that related to that because a media intervener was seeking access to those. And then finally, there was an argument that was raised by the NAACP in a related but separate suit. And unfortunately, I did not get to see that hearing because I had to leave to try to join this live. So I don't know what happened. It was a long day and they were still going when I left around 4:45. So yeah.
All right.
That's what happened.
Folks.
Any questions?
We're going to leave it there. Thanks to Anna Bauer for heroic scurrying from court to where she could join us. Thanks to Molly Roberts. Thanks to Roger Parloff. Thanks to our redoubtable audio engineer, Anna Hickey. And we're going to be back next week, folks, because the trials will keep trialing. The tribulations will keep tribulating, and this has been a production of the Lawfare Institute. You should join us in the live studio where you can get your questions answered, become a material supporter of Lawfare. And next week, you can be like Andrew, asking your pardons question to the live panel. Folks, we'll be back.